So why don't we bring in Mark Zaid into this conversation? He's an attorney who specializes in cases involving national security and security clearances. And I wonder what you can add to what we know so far about this. We don't want to get ahead of it. But from even the rundown of what investigators were looking for when they went to Mar-a-Lago, and then the concerns now about releasing everything to the public, what are your thoughts?
Well, I agree with everything I've heard so far. It's very, very unlikely that the federal magistrate judge will order the release of this affidavit. I've pursued these types of affidavits many times over the years, and when the government, a federal agency, invokes the law enforcement pending investigation exception to either under the Freedom of Information Act or dealing with a First Amendment right that some of the media outlets might be pursuing, that pretty much puts a kibosh on it. You know, what we've seen so far with the warrant and then the receipt of information, which frankly supports that the warrant was a proper application of a search of the property, you know, reveals that there was an interest in clearly someone on the inside was telling federal law enforcement officers that what they were being told over the timeline that extended over a year, that they were not getting the full story from the Trump team. Now, we don't know who that was, of course, saying. We know that there was a declaration or an affidavit or some sort of assertion from at least one or two of his lawyers that said there is no longer any classified information at Mar-a-Lago, which clearly turned out to be false. So we have that fact pattern right in front of us that shows everything so far has been justified. Doesn't mean that the Trump supporters will obviously accept that, but I think objectively, anyone who looks at it legally certainly is going to say that it's been a proper process to date.
First, how long will it take for them to go through the documents and sort of match them up with what they were looking for? And is there anything in what we know so far, unequivocally, that indicates that they found what they were looking for?
Well, the fact that they found, at least as we know from the receipt, properly marked classified documents at the confidential, secret, and top secret, even top secret SCI level, which is incredibly serious. That means exceptionally grave harm to the United States by definition if that information was outside of secure controls, which Mar-a-Lago would constitute. What we don't know, of course, we don't know a lot, quite frankly. We don't know this issue of, did Trump declassify anything? And we hear his supporters saying, oh, there was a standing declassification order that existed that era. You know, I waved my magic hand and the information was declassified. Now, there could be some merit to that, even though that is completely outside of normal historic process. But we have yet to hear from any former White House or current White House official that there was such and the existence of a standing order. And I've represented several cabinet members from the Trump administration. I have seen no one support the fact that that existed. We also know that there was some media reporting that some of the information, this is not borne out yet by the receipt from the search warrant, that some of the information might have contained nuclear information. Now, if that is true and there was restricted data or formally restricted data, which are the terms we use under the Atomic Energy Act, that information cannot be declassified by the president. That authority is designated to the Secretary of Energy and their designees. So we need to learn a lot more, but at least so far, and of course, what's on the search warrant receipt, there it just refers to, you know, binders, boxes. So we don't know how many documents might in fact be in those. So I have had the FBI, when they've seized clients' records of mine, or, you know, my clients' records, take months. Hey, I think I still have a client who hasn't gotten back files in 6 or 8 years. But that's not going to happen in such a high-profile case, obviously, as the former president of the United States.
So, Mark, the Espionage Act has been invoked quite a bit over the last week and a half or so. A lot of people scrambling to familiarize themselves with that. How would that apply here? Because you've sort of come out and said, let's pump the brakes on that unless there's really something to pursue there.
Now, you know, the Espionage Act is a very confusing statute to people because when you hear it, you're like, oh, that means the person's a spy? Sure, it could. But the Espionage Act, which dates back now over a century, has multiple provisions. Some of the provisions deal with old school spying. Robert Hanssen, Aldrich Ames, you're spying for the Russians. Other provisions just deal with leaking classified information to the media. Other provisions deal with the mishandling of classified information, which would pertain to what we're talking about. But I'll have to even correct myself because so easily I say classified information. The Act actually talks about national defense information, which predates our current classification system. We equate it with classified information, and I don't know of any modern cases where someone was initially prosecuted where the information, the national defense information, wasn't classified, but we look to it as being generally classified. So the Espionage Act absolutely has an application so far from what we've seen to the facts. Obviously, we have to wait and see. It's also very statutorily derived in the sense that the level of harm, as I said earlier, exceptionally grave for top secret information. It's written right into the executive order of which the statute applies when the courts would look at these types of determinations. But, you know, again, we're still in somewhat of an early stage of many of these issues.
Mark, Elise Jordan here. I have held a top secret SCI clearance in the past, and frankly, sometimes that information that you're lucky enough to see, it can be a little bit underwhelming. And that's what I wonder about what we saw listed in the receipts here. We saw that there were, 10 document sets, and 3 were secret, 3 were confidential, so that's probably not anything that juicy. And then the 4 sets were top secret. But there wasn't anything marked, as you said previously, as restricted data, which would be nuclear information, or special access program. So do you think that, much like Hillary Clinton's emails, that yes, there was some top secret information, but it turned out to be pretty underwhelming? Do you think that there is a chance that what's in these documents is not going to be actually earth-shattering and perhaps an example of the government overclassifying?
Well, I think to a lot of people, if we ever do find out any of the information that is supposedly classified, people will see it as underwhelming. I've litigated against the government for 30 years now to declassify information. I hold a TSSCI eligibility clearance myself from the cases that I handle. And yes, routinely we see overclassification and we are underwhelmed by the information. Under the executive order that exists and governs this, which President Obama issued in 2009, Executive Order 13526, under, in fact, all the executive orders that have existed for decades, something as general as the foreign relations of the United States can be classified. So that one document that refers to the president of France, if President Trump wrote, I talked to the president of France, really nice guy, that can be classified, properly classified. So that is definitely something to take into consideration. I often am able to beat back classification determinations of the United States. Overclassification is a serious problem. And President Trump or whomever, because there are other people who might be criminally responsible if the facts justify, will have an opportunity to challenge some of that information. And the judge, through the Classified Information Procedures Act, which is the statute that applies to this type of case, will, of course, look at all the documents and make determinations as to whether or not they're classified properly or not.
All right, Attorney Mark Zaid, thank you. He specializes in cases involving national security. We appreciate your being on this morning.